Hello, I'm Rachel from Strategic Solutions Chartered Financial Planners. Today we're exploring the importance of wills and power of attorneys. Taking the proper time to plan around your finances can ensure that your finances are dealt with in a way that you wish, in a time that you may be incapable to make those decisions or when you have passed. So, let's explore wills first. It is estimated that as many as 60% of people don't have wills. If you die without one, your estate will be distributed according to strict rules, meaning that people you care about may lose out. A will is a legal document you create that sets out instructions for who will inherit your estate and what should happen after you die. It includes what sort of funeral you would like, how you would like your possessions to be distributed, as well as other wishes like who should bring up your children if you have them. Sometimes known as your last will and testament, it is a legally binding document, but if you don't prepare it properly, it may not be valid, and so we believe it is key that you enlist the support of an expert will writer. Here are some of our top reasons to make a will. When writing a will, you don't just decide how your estate is divided up. You also have a say as to who should look after your dependents. If they are under 18, you can also appoint their legal guardians. If you don't, the decision could be left to the family courts, who may choose a person you wouldn't agree with. You may have named friends or family members to be your children's godparents, but this isn't legally binding. As well as saying who will raise your children, you can make plans to provide for their future financially. This might include putting money aside for their education, making sure they receive a set amount each year for clothing or hobbies, or establishing a nest egg to buy a home. You may wish to consider setting up a trust to provide for your children, as this gives you an element of control over when your children receive the money and what it gets used for. There are two ways to set up a trust. You can either establish it while you are still alive, or leave instructions for it to be established when you pass away. Your stepchildren may be a big part of your life, or even be your only children, but the law states that only spouses or blood relatives can automatically inherit if there is no will. If you want to provide for your stepchildren, you'll need to write a will that includes them. The same goes for foster children or any other dependents who may rely on you for support. Unmarried partners aren't entitled to anything from your estate unless specifically stated in your will, no matter how long you've been together. Writing a will ensures your partner will receive their fair share of your estate. If the family home is in your name, your unmarried partner and stepchildren aren't automatically in line to inherit if you die without a will, meaning they may lose their home. You can leave them a share of the property in your will or a right to reside in the property. Dividing up an estate can sadly sometimes lead to squabbles and arguments amongst your survivors if there is no will or your wishes aren't made clear. Contested wills can be damaging to relationships among your family and can also be expensive if decisions about your estate are legally contested. A well-prepared will can help avoid these arguments and avoid making your passing even more stressful for your family. The amount of inheritance tax that will be charged on your estate depends on how much you have and also who you leave it to. Anything left to your spouse or civil partner will be automatically exempt from inheritance tax. Leaving property to your children and grandchildren is also likely to generate a lower inheritance tax bill than leaving it to others. When you marry, your existing will becomes invalid in England and Wales. According to the rules of intestacy, this means your estate could end up split between your new partner and children from a previous marriage, potentially causing arguments. Getting divorced doesn't override your will, which means your ex-partner may still be in line to inherit from your estate. As such, it makes sense to regularly review your will so it still reflects your situation, particularly after a marriage or separation. Within your will, you can name an executor or multiple executors who will be in charge of carrying out your final wishes. Choosing your executor in advance allows you to select the best person for the task. It also gives the executor prior warning so they can prepare themselves. If you support a charity, you may wish to leave something for them when you pass away. As well as supporting a good cause, you could potentially reduce the amount of inheritance tax paid by your family if you leave more than 10% of your estate to your chosen charity. Now, let's take a look at lasting power of attorneys. A lasting power of attorney is a legal document that allows you to appoint one or more people to make decisions on your behalf during your lifetime. The people you appoint to manage your affairs are called the attorneys. A lasting power of attorney is a completely separate legal document to your will, although many people put them in place at the same time as getting their will written as part of planning for the future. There are two types of lasting power of attorney. A health and welfare lasting power of attorney lets your attorney make decisions about your medical treatment and day-to-day care. This can include where you live, what you eat, what medical treatment you receive, and who you see. A property and financial affairs lasting power of attorney lets your attorney handle and make decisions about your money and property. This can include paying your bills, selling your property, collecting your pension, and collecting your benefits. If you become unable to express your wishes, a lasting power of attorney enables someone to step in and make decisions for you about your health and care or your finances. These important decisions will be made by someone you choose and trust, and you can choose the right type of lasting power of attorney for your circumstances. A lasting power of attorney is significantly cheaper than the alternative, which is a deputyship order. A lasting power of attorney comes into effect as soon as it is needed, so your chosen attorney can step in straight away. Once you have a lasting power of attorney in place, you can have peace of mind that there is someone you trust to look after your affairs if you become unable to do so yourself during your lifetime. This may occur, for example, because of an illness or old age or an accident. Having a lasting power of attorney in place can allow your attorney to have authority to deal with your finances and property, as well as make decisions about your health and welfare. Your lasting power of attorney can include instructions for your attorney, as well as your general preferences for them to consider. Your lasting power of attorney should reflect your particular wishes, so you know that the things that matter most would be taken care of. You can only put a lasting power of attorney in place while you are capable of understanding the nature and effect of the document. If you lose this capacity, you cannot enter into a lasting power of attorney, and no one can do so on your behalf. Many people don't know that their next of kin has no automatic legal right to manage their affairs without a lasting power of attorney. Without a lasting power of attorney, making decisions on someone else's behalf can be a long and significantly more expensive process. Hopefully, this video has helped highlight the importance of proper planning and ensuring you have valid wills and power of attorneys in place.